There continues to be a lot of discussion about alternative billings, and I think from the very beginning we need to define what we're talking about. We're talking about essentially any alternative to the billable hour. That means contingency work, such as in personal injury or debt collection. That means fixed fees, as in negotiated contracts. That means letting the client determine what the price will be by virtue of enabling the client to increase or decrease the amount that's billed to you. One law firm, for example, sends a bill with suggested amounts by activities, but does not total the bill. And at the bottom of the bill puts a plus and a minus, allowing the client to total the bill, to add to it as a reward, or to take away from it in the event they're not happy with any aspect of the service that was delivered. The problem with the latter, of course, is that they may not be happy with the result. That may have nothing to do with the work that the lawyer did. And so you run that risk. But there are some law firms I know that are doing that. Now, to me, that is the ultimate in value billing. But let's take, for example, just for the moment, the idea of a fixed fee as the alternative to the hourly billing. From the client's perspective, what's the advantage? The real advantage in such a situation for the client is certainty. In today's world of corporate America, even general counsel are being required to submit budgets to their management, and they have to show that the percentage of the legal expenses are a certain level of the revenue of the firm or lower. That is, that they're saving money, that they're lowering their legal costs as a percentage of the revenue of the company. Another aspect of the fixed fee is an element of trust. That is, once it's negotiated, once the fee is negotiated, the client, corporate America, has trust in the lawyer. They know what the number is going to be. It doesn't matter whether the lawyer and the law firm spend more time or less time, more resources, less resources, more personnel, fewer personnel. None of that matters to the client. They have trust that the number is set, that the lawyer, the law firm will provide the service that's been negotiated for, and that the lawyer and the law firm are competent to do that which was asked for. So between certainty and trust, these are two significant elements for the client. Let me go back just for a moment to the idea of certainty. One of the things that clients hate most is surprises. And surprises come in many forms. They can come in the form of the result that's attained, because that's a surprise. They expected to win, they didn't, or they didn't expect to win but wanted to provide a good defense, and now all of a sudden they won. Whatever the surprise is, clients hate surprises. They really hate the surprise in terms of the cost of the delivery of legal service. So again, the idea of certainty and trust are paramount for the client. From the lawyer's perspective, let's ask what is the benefit for him or her. Well, one of the things we fail to really recognize is that technology is a component of competence. And if you fail to advance your technological capability, it is conceivable that should your competence be questioned, the governing body, the state bar, the disciplinary board, may determine that you were not really competent to handle the matter that you did. Why? Because you were not sufficiently competent in the handling of the technology of the day, as contrasted with other competitive lawyers and competitive law firms that are using a more advanced technology. Well, that's all well and good, but in order to stay competent, in order to stay current in the use of technology, what must you do? You've got to invest. That costs money for the hardware, costs money for the software, and costs money for the learning curve. to get up to speed to running that particular kind of software and that technology. If you are billing at an hourly rate, your investment in the technology oftentimes cannot be recouped. Why? Let's assume that one of the objectives of the use of technology is that you can do more in less time. If you do more in less time, you can bill less. Well, you can bill less is sort of euphemistic. You must bill less because you're spending less time. If you bill less, now your revenue is lower. Or you got to hustle and get more clients to stay even at the same revenue. Where's the payoff then for investing in the technology? There's not. But if you've got a fixed fee and you can invest in technology, whatever savings you develop, whatever efficiencies you develop, whatever savings in terms of time you develop, that stays in your pocket. That's not transferable to the client. Why? Because you've developed, you've negotiated, and the client has accepted a fixed fee. Here's where it's really beneficial to the lawyer. Clients are not particularly concerned with your efficiencies, I believe. They are if you're at an hourly rate billing, but not if you're on another method. What they are concerned about is the speed with which you deliver your service. And technology will help you deliver your service, the end result, the product, the contract, whatever it is that you're working on, faster. That's what they're looking for. Oh, and did I forget to say that with the technology, with the speed of the delivery enhanced, it is likely that your profit per unit of time will be enhanced. That's what's important. That's another aspect of alternative billing that I wanted to raise with you today. Think about that from your perspective, and then think about how you can market those benefits that you receive to your client and put it in their self-interest of certainty and enhanced trust. Thanks for joining us today.